All right, we are here this afternoon. Good afternoon. We're here this afternoon for two specially set hearings on for the Kansas Court of Appeals on our March docket. I'm Judge Tom Malone. We also have Judge Kim Schroeder, and finally we have Judge Amy Klein. We are the panel for today's cases. I'll call the two cases in the order of our published docket. When I call your case, we'll start off with the appearances and then get into the case. I think many of you know, but I'll just say anyway, we have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind during the limited amount of time that you have to make your argument. As the presiding judge, I'll be the timekeeper. Each party is designated 15 minutes for your argument. The appellant's attorney should let us know at the beginning of your argument if you wish to reserve any time for rebuttal. After the hearings today, your case will be deemed submitted for decision, and that means we will take the case under advisement and get a written decision out to you and your clients just as soon as we possibly can. So with that, I'll call the first case, and it's from Sumner County. It's 127-188, entitled The State of Kansas versus Samuel Roman. And who do we have here for the appellant?
Martin Peck, appearing on behalf of the appellant Samuel Roman.
And Mr. Peck, do you wish to reserve any time for rebuttal?
3 minutes, Your Honor.
That is granted. And for the appellee?
Assistant Solicitor General Ryan Ott, appearing on behalf of the state of Kansas.
Is your name on the brief anywhere?
It's not on the brief. I entered my appearance for argument.
Okay, all right. All right, Mr. Peck, whenever you're ready to proceed.
May it please the court, Your Honor, and as you said, you've read the briefs, and they're short. I have a few points of emphasis. With respect to the search, the state had the burden of proof on the search. The initial deputy was clearly within the defendant's curtilage when he was standing on the defendant's porch. And then he walked away from the porch to dog kennels, and at some point, we left the curtilage. Again, the state had the burden of proof, and the evidence on where everything was, how far things were from one another, the layout was sketchy at best. With respect to distance, the court ended up relying in part on a photograph, that's Exhibit D, that the defendant produced. That's in volume 16 at 9, which shows a picture of cattle pens. There's no house in the picture, so we don't know exactly where the house is from that, at least on the evidence presented at that time. One of the four done factors is how far away was the search conducted. And the work the court had to do, the work the trial court had to do to try to figure out where everything was in relation to everything else, suggests the state did not meet its burden of proof on that. With respect to the other plank that the trial court found to be indicative of this being an open field was the use that dog kennels were put to, that being an agricultural use that would have smelled. Now, my first reaction to this was that really didn't cut that way. I've woken up in the morning and seeing cattle outside the bedroom window and dogs on the front porch. People and animals have for a long time lived kind of on top of each other. So I went to go find at least some documentation that was true. And, I've never put pictures in a brief before, but that's why those are there. I mean, the history of animal husbandry in the United States, that history and tradition suggests that people and animals sometimes live on top of each other, sometimes in the same building. The history from Kansas and Nebraska, those two photographs I found were of pigs in the front door. I mean, it doesn't get much smellier than that. That's not reweighing the evidence. I mean, you don't get evidence of that sort of background in a case regardless.
So, Mr. Peck, are you saying that the kennels being 300 feet away from the house is still within the curtilage or not?
Well, Your Honor, I don't know if the evidence indicates that. I don't think the evidence at the hearing figured out how far away that camels were. But if they were 300 feet away, I mean, if that's in evidence in the suppression hearing, if that's in evidence, that's certainly a factor to be weighed. But in agricultural areas, sometimes things are a long way away. Sometimes they aren't. It's a very fact-intensive thing. But I think that what the state needed to demonstrate at the trial was, how far is that? Not at the trial, I mean, at the trial, at the suppression hearing, how far is that? I mean, they had the burden of proof on that fact. And again, the court had to do a lot of intuiting to try to figure out how far the kennels were from the house. And again, the use of those kennels, being animal husbandry, that's common in agricultural areas. And that's not something that needs to be in evidence any more than that, where people garden would need to be in evidence to figure out what gardening or parties or these are things that people know. Now, I guess one of the things about some of history and tradition in application of the Fourth Amendment, you do run into things that people don't necessarily know. I mean, I didn't know off the top of my head whether I could find what I expected to be able to find, some amount of verification for people and animals living on top of each other. I was able to find some of that. It was not as easy as I'd hoped. With respect to the argument coming out of State versus Ellis, that's an unusual framework for that argument, but it's what the court said. It said, look, if you do a welfare check and the welfare check ends, you got to leave. Now, that's not, those cases were not exactly the same as this case, but that's what the court said. The investigation has to be over. Stop. And in this case, I think the evidence is pretty clear that once the officer determined there were no people there to have welfare checked on, that he did not, in fact, stop. He continued on onto the property. With respect to preservation, if there is another case like this one, I have hunted for it and can't find it. I looked harder than I was willing to bill the county for to try to find cases where a pro se defendant had raised and re-raised an issue that was denied by the court both before trial and the eve of trial, and that issue was wholly dispositive of the case. And frankly, there aren't very many preservation cases where that's true, even with counsel. But I think with counsel, you run into State versus Jones and State versus Nunn, and probably counsel would have been foreclosed, although not necessarily, because this was a bench trial. And the Supreme Court has held that this court, the appellate reviewing courts, have the discretion to determine whether an objection that was made not contemporaneously can still be timely. Because I don't think I can get around the statute. But Mr. Roman, not a great litigator, but Mr. Roman made quite clear. I mean, the judge said more than once that he understood what Mr. Roman was raising. He raised it as a pretrial motion. He asked for reconsideration of that motion. He tried to repackage those on the eve of trial. No one had any lack of clarity. And if all he'd said was, Your Honor, I'd like a continuing objection on this issue, he'd have gotten it, and we would not be litigating preservation. In this particular case, I think, the question of form over substance, in substance, there was no question that evidence was objected to as being seized warrantlessly in a trespassory manner, and it was that. Judge Mott just determined that it also was not excluded under the Fourth Amendment. So I don't think it.
Just to be clear, you're only making a claim under the Fourth Amendment, not under the Kansas Constitution. Is that correct?
We understand them to be coextensive. I mean, I think it's pretty clear that the Kansas Supreme Court has articulated that the edges of those amendments are the same. The Kansas Supreme Court has said the open fields doctrine applies in the state of Kansas. I don't.
Well, correct me if I'm wrong, but I don't remember you mentioning the Kansas Constitution in your brief.
I don't know that I did, Your Honor.
All right.
But again, I don't think it would lead to any different conclusion than with the United States Constitution. But the main reason I want to have oral argument is in case the court had any questions, and I'm open for questions if the court has any.
Counsel, I'd like to talk to you about that last factor in the open fields doctrine test. And you've talked about one aspect of the court's ruling with respect to the smell of nearby animal husbandry. But the way I read the court's ruling, the court also mentioned the fact that this was a commercial operation and that it was subject to inspection at any time without notice by the Kansas Department of Agriculture as a condition of their breeder's license. So can you speak to me about how we should consider those facts under this particular aspect of the test?
Well, Your Honor, with respect to the commercial factor, animal husbandry has been a dual purpose activity for 200 years. I mean, you raise animals, you eat some, you sell others. My family's in the agricultural business. We don't eat anything we raise. It all goes someplace else. But that doesn't keep cattle from being in the yard. And so I don't think that the fact that it's commercial, given that it's animal husbandry, cuts much of either way. I think that it could be either place. With respect to the Department of Agriculture being able to make an inspection at any time, that's also going to be true wherever it is. I mean, as a condition of his license, you know, if they had the dogs in the garage or in the living room, and I think, you know, some of the dogs that were seized ultimately were immediately adjacent to the house. Whether or not the Kansas Department of Agriculture can come inspect, whether it's in the curtilage or out of the curtilage, is not going to bear upon the Department of Agriculture's ability to do that.
But doesn't it impact your client's expectation of privacy in that area? Wherever
Not
they
from the
choose
Sheriff's
to keep
Department,
the
no.
animals that are subject to inspection without notice?
Not with respect to the Sheriff's Department. I mean, if you have a commercial enterprise in your home, yeah, the regulators can visit, but you can't. I mean, I don't think the Sheriff's Department ought to be able to say, hey, we knew these other law enforcement agencies, these other government agents could come in without a warrant, so we do too. You clearly have waived your rights to have anybody come check. I mean, I just don't think that's accurate.
Well,
doesn't this
doesn't
test
it
really
go
look
to
at-
expectation of privacy? I'm sorry isn't that the point? It goes to expectation of privacy.
Well, Your Honor, if that argument were to work, it proves way too much. It means that everybody who has any kind of commercial enterprise in their house or within the curtilage can have government agents come in for any reason they want or no reason. And that doesn't seem right. It does seem to me, though, that if these had been agricultural officers doing the search, that would have been a very different case. But, you know, you don't waive all your Fourth Amendment rights against every government agency by waiving them with respect to one agency. I don't think that I'm not aware of any law that says that. That would be, I think, an odd result.
So are you advocating for a test that is dependent on who's looking as opposed to from your client's perspective? I mean, it sounds like to me you're saying the test is going to depend on what agency is there as opposed to what your client could expect.
Your Honor, in the event that the agricultural department was doing this, or the Department of Transportation with a trucker, or the cosmetology board with respect to somebody who cuts hair, those people all have a right to come inspect premises for a business purpose, separate apart from the warrant requirement. So the Dunn test doesn't even come up. I mean, if you're there at a reasonable time, you can inspect. And there's no question of whether you needed a warrant. We don't get into whether it's in the curtilage or out of the curtilage. We just ask whether it's a licensed area. But I think the argument that if you conduct business within your curtilage, you don't have a reasonable expectation of privacy there with respect to anybody proves way too much.
All right, you've used 12 minutes, so you still have your 3 minutes of rebuttal.
Your Honor, I think that we'd ask that you reverse. In the event you think we're wrong about one aspect of the Dunn test and not the other, didn't occur to me until later. that might suggest a remand. But if we're right, Your Honor, none of this evidence should come in. And dismissal, reversed and rendered, is the way to approach this.
Thank you.
Thank you.
Mr. Hott?
Good afternoon, Your Honors. I would like to start with the factor that you guys ended with, and that being the nature of the use of the kennels. Judge Klein, you talked about it being used for commercial issues or for commercial purposes. And that's true. And part of the district court's finding was, in fact, that it was subject to inspection anytime by the Department of Agriculture. But another part of the district court's finding that it was used for commercial purposes is that this Dunn factor asks whether it was used for intimate activities of the home. And the purpose of what the district court was saying is not just that it was subject to inspection, but as a commercial enterprise, as a business, this is not an intimate activity of a home. This is a business. This is not gardening, I believe, is one of the examples that the district court used. That this is not, there's no evidence of gardening or any things that people tend to do in and around the home. And that is why the fact that it was commercial enterprise, the nature of the use of the dog kennels was the strongest factor in the district court's mind in weighing that this was not curtilage and this was subject to the open fields doctrine. This was an argument that Mr. Roman did not address in his brief, focusing instead on this history and tradition of barns and of livestock in and around the home. As to that, I know Mr. Peck today argued that it is not new facts, new evidence. The state would argue his fact is he relies on a book that was not entered into evidence before the district court. This was not able to be tested or argued in front of the district court. These are new facts that are being admitted, or that he is arguing now for the first time, and the court shouldn't consider them. However, even if this court were to consider those facts and those evidence and weighing the Dunn factors, the state would argue it's not very persuasive. While there might be a history in some areas of the country, even in Kansas, Nebraska, of barns being attached to homes or animals being in front of or in and around homes, that was not the case here. These dogs were in kennels that were located approximately 300 feet away from the home. They were not loose or in front of the house. They were not attached to the house by any means. And so this argument of a history of animals or of barns being close to homes do not apply to this situation.
I thought the best finding we had was that the kennels were 75 to 100 yards from the house. Is there something specific about 300 or 300? Or did you say 300 yards?
If I did, I meant 300 feet, Your Honor.
Okay.
Just to make sure to clarify, at the suppression hearing, the court found that the kennels were between 75 and 100 yards from the driveway based upon a map that showed the distance, as well as testimony from the deputy that the map was accurate. And then at trial, the deputy testified.
I'm sorry. Wasn't there a photo, an aerial photo of the property admitted into evidence that had the distance from the back of the house to the kennels?
Yes, Your Honor. There was a photo. It's a Google Maps photo. It appears to be that where you can measure distance, and it shows the distance from the driveway to the kennels and from the house to the cattle pens and the house to the kennels. And it shows it was slightly over 300 feet. At trial, the deputy testified that same distance as well.
And refresh, who entered that exhibit, the defendant or the state?
That was a defense exhibit. I believe it was Defendant's Exhibit D.
Okay. Well, I have Exhibit D, and it's just a picture of the trees in the corral.
Okay. I can tell you.
I don't see any dog kennels in it.
It's in. I'm sorry that I got the letter wrong. I don't know it off the top of my head, but it is in Volume 1, pages 224 to 227. Will have the maps.
Thank you.
You're welcome, Your Honor. And that distance, as you brought it up, it goes to that the factor of the proximity of the dog kennels at home. I think it also goes to the nature of the use, and that it was farther away. There was no examples of activities at home being extended to it. But as you brought up the distance, Judge Schroeder, the other factor that the district or court found weighed in favor of it being an open field is the proximity to home. Admittedly, the district court noted that it was not entirely clear how far away it was and that it had to do an estimate. But based off the map and off of the deputy's testimony, as I stated earlier, the district court found it was between 75 and 100 yards. It noted that it could, from the driveway to the dog kennels, it noted it didn't have an exact distance to the house. It stated that if it tried to find that distance, it would be speculating. It did note that it was at least 30 yards away from the house. And
so you're basically telling us the court didn't rely upon the exhibit of the Google Earth picture.
The district court stated it relied on the exhibits of the pictures and relied on the pictures and on the testimony from the deputy that those pictures were accurate. It stated that in its findings, and then it stated that it found that the kennels were between 75 and 100 yards away based on those findings. However, courts, our Supreme Court in Martin has held that courts can rely on testimony from both the suppression hearing and relevant testimony from the trial when it's determining whether substantial competent evidence supported the district court's findings. And at the trial, the deputy testified that the kennels were between 300 and 350 feet. I would argue that this provides further evidence that the district court's findings were correct, that the proximity or lack of proximity from the kennels to the home weighed in favor of finding an open field instead of it being within the curtilage. Now, the district court did find two factors weighed in favor of it being curtilage, and that being whether the area is included within the enclosure surrounding the home and the steps taken by the resident to protect the area from observation by people passing by. And it noted the fact that there was trees lining the roads and partially obscuring the dog kennels, that there was no sidewalks or walkways to the pens. The state would argue if there is an error in this case by the district court, the state acknowledges that there's substantial competent evidence to support these facts, but if there's an error in the legal analysis, it was here. I'm sorry,
I have another question. Has the issue of restitution been resolved? Our records reflect that it was not resolved and was still open.
I don't know, Your Honor. That was not. I hate to use the excuse, but I didn't brief this case. I tried to focus on what was raised in the briefs, and that was the suppression issue.
I'll ask Mr. Peck when he comes back.
Okay, sounds good, Your Honor. As I was saying earlier, this court in State v. Tinsley found that marijuana found behind a barn that was not visible from a public road and was only 45 to 70 feet away from the resident was not considered to be within an enclosure surrounding a home. Here we have animals, dogs, that were much farther away, were only partially obscured, and the state would argue that if in Tinsley that marijuana hidden behind a barn is not within the enclosure surrounding the home, then neither should these dogs be considered so. With that being said, you don't have to find every factor or even a majority of factors under the Dunn test to constitute open fields. The state believes that the district court's findings, the evidence supported the district court's findings, and that the dog kennels were in an open field, the Fourth Amendment doesn't apply. If there are any further questions from the court, I'm happy to answer. Otherwise, I'll reserve the rest of I'll give up the rest of my time.
I don't.
Seeing none, I would just ask that this court affirm. Thank you.
All right, thank you, counsel. Mr. Peck, you still have your 3 minutes of rebuttal. You're muted.
Thank you, Your Honor. To begin, there is an aerial photo in the record from Google Maps. It was never admitted into evidence. What was admitted into evidence, and this is a little strange, but at the hearing where the issue of distance was relevant, the state put on no evidence of distance. That came in a brief that was written after the hearing because the issue came up at the end of the hearing. The Exhibit D that's referenced, Judge Schroeder, you're right. That's a picture of like cattle pens. You can't see a house. You can't see the dog kennels. And the judge made almost no finding regarding distance. If you look at the findings about distance when he made them in connection with the Dunn test, those are on pages 287 and 288 of volume 1, where he says, hey, I'd be guessing, but it looks like it's within the walking distance of the house. And if you look at Exhibit D, I can kind of try to figure out where it is. And the court can infer that Roman's house is not within 30 yards of the dog kennels. So I suppose you're translating that to be at least 90 feet. But I don't think that Exhibit D in the testimony gets you to that either. And so
how did we get the aerial photo if it was not admitted into evidence?
it was attached to the state's brief filed after the hearing.
To the
Was it
state's,
before the decision?
Yes, but the judge didn't rely on it. And I think properly so. It wasn't in evidence. I mean, it wasn't presented in evidence. There's no testimony regarding it. It was never offered. There was, even Mr. Roman might have been able to argue that that was hearsay. But I don't know. But that map was never relied on, as far as I'm aware, by the district court for any purpose. He also never really revisited the Hyatt finding under Dunn. I mean, so that there may be other evidence in the record about where things were. They were never presented in connection with whether or not the search was suppressible under the Fourth Amendment. The evidence that you've got that really pertains to that is the evidence that came up in the hearing, and that's volume 10, I believe, of the record. And then Judge Mott's decision on that, which, I mean, I disagree with his outcome, or a part of his outcome, but you can't accuse him of not paying attention. I mean, he did a good job of evaluating the evidence that was actually presented. But that starts on volume 1 of page 271. And the relevant findings we're talking about, again, are on pages 17 and 18. And it's a page and a half of evaluation. And I think he says, I'm going to have to be speculating. It's going to be at least this or more than that, or this on the other side of that. We'd contend that he didn't have substantial competent evidence to figure that out. Your Honor, the restitution issue has not been resolved. I don't know that it ever will be. The state had asked for restitution at one point. I don't know whether it will be again, and if they do, I don't know whether we'll take the position that it's timely. But at this point, the state hasn't asked for restitution. I think probably as a practical matter, you're never going to get it. I don't think you'll ever get it out of Mr. Roman.
well, but there's no order of restitution.
Not that I'm aware of.
So doesn't that make the sentencing incomplete until restitution's been determined?
Your Honor, I've not researched that. I don't know.
All right. I appreciate the honesty in your answer.
Well,
'Cause
there's
there's many
no-
times I
there's
don't
no
know
special
either.
line to you, bet. I mean, I read pretty well, but I don't happen to know everything. So
I get-
I don't know that it is.
Hearing no further questions, thank you, counsel, very much for your briefs and your arguments. We'll take the case under advisement and get a written decision out to you and your clients just as soon as we can. Thank you.
Thank you.
Have a good day.
I believe we are on the record now. We'll take up the second case this afternoon. It's from Sedgwick County. It's number 127773, entitled Mandala Community LLC versus Adam Denton. Who do we have here representing the appellant?
Joshua Albin of Adams Jones Law Firm in Wichita, Kansas, for the appellate Mandala Community.
And who do we have for the appellee?
Your Honor, for the appellee, we have Bryant Barton and Kim Condon with the Disability Rights Center of Kansas.
You'll be doing the argument, Mr. Barton?
Yes, Your Honor.
All right, Mr. Albin, do you wish to reserve any of your time for rebuttal?
2 minutes, Your Honor.
What, 2?
2 minutes, Your Honor.
All right. That is granted, and you can begin whenever you're ready.
Thank you. Your Honor, this comes from an appeal from the Magistrate Court for a landlord-tenant case where we had a landlord that was seeking eviction for violations of a lease agreement. After the initial trial, the eviction was granted where the defendant was at that time pro se. He soon sought counsel and was able to get a motion to stay, and we had a subsequent hearings about
Counsel,
the determination.
Can I ask you a question?
Yes, Your Honor.
Does Mr. Denton still reside in the home?
No, Your Honor.
So if he's no longer in the home, does that make the issue moot?
Yes and no, Your Honor. The big issue here is the determination of whether or not the Residential Landlord Tenant Act applies.
But aren't you asking for an advisory opinion if there's no, you didn't get a money judgment against Mr. Denton, is that correct?
Correct.
So you're just wanting an opinion telling us whether or not the Landlord Tenant Act applies to residential facilities like your client operates.
Correct. I think that this has a large, wide-reaching opinion that affects tens of thousands of Kansans that are in the IDD programs that are administered by the Kansas Department of Aging. At this point, my understanding of this ruling is that it basically stripped not only the landlords of their rights, but also the tenants to have rights under the Landlord Residential or the Residential Landlord Tenant Act. When we determined that the act was inapplicable to these types of facilities, it had far-reaching implications than just one specific case.
Well, didn't the lease agreement have provisions within it that provided for dispute resolution, such as tenant leaving the facility?
It had very specific administrative appeals that were through the administrative process, but that wasn't necessarily for the living arrangements, more along for the services that were provided by the lessor at this time. Mandala Community not only operated a residential facility that housed and paid for different things, but they offered basically attendance services that went along with it to complete the community integration services that were required by HCBS as well as Kansas Department of Aging.
This is not a normal landlord-tenant relationship.
It has very specific parts of it that are akin to those that are living in attendant homes. There's a lease agreement. They pay rent. They pay service fees that pay for utilities. There's many different landlords that afford utility services and things like that and offer additional services. It's not as typical as somebody going to an apartment here in Wichita and just leasing an apartment, but there are certainly places where you can have full residential services that include house cleaning as well as full room and board, food as well. I don't see the difference between having a full room and board lease agreement is any different from what we have here, other than one very specific thing, which is medication management.
And didn't you also manage the some personal care items?
We help them with their personal care items as home attendants, but not necessarily dictated what their home care products were going to be. We facilitated the ability of buying them. We facilitated things through the guardian relationship as additional services, but it's not one that is of absolute control.
Thank you.
Let's
overall
let's shift gears here and try to get to the merits of your claim. And as I understand, the issue is whether or not the Mandala Community Center is an institution covered by the Landlord-Tenant Act under 58-2541A. And
Correct,
so why
Your Honor.
don't you go ahead and address your arguments on the merits of the appeal?
The statutes are specific about what institutions are. We have several different examples of what institutions are. We have a broad meaning for that of just a regular operation, to more specialized meanings where we specifically outline what institutions are, being Larned and Osawatomie. When they wrote the Residential Landlord-Tenant Act, they were overly vague and allowed this one line that says institutions that are incident to imprisonment, to medical conditions, and when we kind of leave it out, the argument is that because there's some additional medical type services that were offered by Mandala, that they become to an institution that is specifically held out from the Landlord-Tenant Act. But when we actually look at the legislative intent, we don't actually see anything that goes along with those meanings. And when we have to reconcile those meanings with additional federal regulations as well as state regulations, they don't exactly marry together. So we have the final settings rule, which is under the federal statutes and regulations for Medicaid services and HCBS services, which specifically says that those types of services that we have here are not part of an institution. And it specifically outlines that because there's an underlying opinion that there has to be freedom of movement, freedom of travel, which is afforded to those that are in group homes like Mandala versus those who are in nursing homes, who are in group homes that are subject to, say, like the Sexual Predator Treatment Center there at Osawatomie. There is an aspect of freedom and freedom of choice, freedom of travel that are associated with those types of institutions, which I believe is what the legislature was contemplating when they added those types of things in there. It's that actual freedom of movement, that freedom of choice. When you don't have a choice, then your ability to argue under the Landlord-Tenant Act should be revoked. But when you do have a choice, when you have a specific right to choose where you live, to choose where you travel, to leave, to come and go as you please, then that legal mechanism between the landlord and the tenant has to be there. In this particular case, there is no other legal mechanism for the landlords to redress issues with violations with the lease agreement. There's not specific jurisdiction that is granted upon the administrative courts under the regulations in Chapter 30 for the licensing of these types of facilities that grant them some type of relief that's there. That's because we already have that relief as part of the Residential Landlord-Tenant Act. And when we have no other mechanism for redress, I believe that it's intentional because we didn't mean for these types of institutions to be left out of the Landlord-Tenant Act. Overly, what we're looking at here is how do we marry these final setting rules and the regulations all together that says you have the ability to move, you have the ability to change, you have the ability to be treated like everybody else, which is the overreaching public policy in this case, and then all of a sudden say, no, you don't, is that you don't have the right to choose. You have to go through the same administrative regulations and the same administrative things as if you were choosing a service provider, and that you don't necessarily have the same type of redress if there was mold issues in your apartment versus whether or not you're not paying your rent or not. We have a mechanism here, and if the legislature had meant to take out group homes, then when they approved regulations, when they allowed regulations, they wouldn't have required that lease agreements that were part of these licensed facilities to exist. You wouldn't need a lease agreement. You would only have a service provider agreement, and that would be it. That would be your mechanism for redress. But they specifically allow lease agreements because they meant for these to be under the Landlord-Tenant Act. When
Who meant?
The legislature, and specifically the Secretary of the Department of Aging, who would be the administrator for these types of administrative resolutions that is sought for as part of the regulations under Chapter 63. Go ahead, Your Honor.
So are you telling me that the agreement he signed with your facility has no provision for him to be removed?
The lease agreement does have a provision for him to be removed for non-payment of rent, for violation of the lease agreement. It's the service provider agreement that that we argued about during the trial that had the provisions for administrative recourse.
But wasn't you wanting him to leave because of issues involving his care needs, I guess?
No, the reasons why we had issues with both care needs and the non-payment of rent. He didn't pay rent for 6 months before he eventually left the facility. That's another part of this, is that he just didn't pay rent. The same as you and I would be subject to the Landlord-Tenant Act and eviction under the same notice and the same type of regulations and the statutes for non-payment of rent. If there are parts of our lease agreement that we're not following, then at that point in time, we're subject to eviction. One of the main things that we argued at trial here was the cleanliness of the room that he rented. There was infestation issues. There were things about mice and roaches and all sorts of things that were going in and endangering the public safety of other members in the household that were a major concern to us, that there was specific evidence during the first eviction trial that was brought forward to show. That brought in pictures. We brought in invoices from pest removal and pest control. We had testimony from the managers of the property itself to talk about the cleanliness. We talked about the non-payment of rent, when rent was paid, when rent wasn't paid. It was akin to the same as any other eviction that anybody else would handle in a magistrate court. We talked about proper notice, were they served properly? And then there was the other argument, which is during the second hearing, the manager of Mandala testified specifically that the services that were provided for Mandala could happen anywhere. It does not have to happen in that service or in that particular residential setting. He could have lived on his own and they would have still came over under their service provider agreement to provide the same type of cooking services, the same type of personal care services, and the things that were offered under his person-centered plan that was approved by the Department of Aging and DCF. What we argued is that the residential setting is left separate for a reason. It's because it is meant to be treated like everybody else. It's a least restrictive model that's married between the state and the federal funding agencies that allows for them to have the most integrated setting possible. And after,
For
sorry,
council, you're starting to run into your rebuttal time, so if
Uh,
you want to preserve that, you need to wrap it up.
my overall statement is it's clear from marrying the regulations together along with the law that it's clear that these types of services and these types of residential facilities were meant to be included with the Residential Landlord Tenant Act. And at this point, this should be remanded with specific instructions for that sole purpose.
Thank you, council. Mr. Barton, we'll turn over to you.
Thank you, Your Honor. I would note that the Uniform Residential Landlord Tenant Act was adopted by Kansas and is now the Kansas Residential Landlord Tenant Act. The exception language in the URLTA is identical to the Kansas version. A comment in the URLTA states that this act regulates landlord-tenant relations in residential properties. It is not intended to apply where residence is incidental to another primary purpose. And then it gives examples of prisons, hospital or nursing home, dormitory owned and operated by a college, a residence by a landlord's employee, and situations like that. The URLTA does not define institution or point to other definitions of institution in the law. So given that the URLTA is a uniform act meant to be adopted by any state, a general definition of institution makes sense, as specific definitions would vary from state to state and change the meaning of the Uniform Act exceptions. Looking at the dictionary definition, oh, Your Honor.
No, I have no question.
Oh, okay. An established, looking at the dictionary definition of an institution, an established organization or corporation, which Mandala is an LLC on file with the Secretary of State, a facility or establishment in which people live and receive care, typically in a confined setting or often without individual consent. We would note that residents in Mandala live and receive care, daily living assistance per their person-centered service plan. And although they are not confined and do consent, the definition does not require confinement or lack of consent for it to be an institution. So the appellee is arguing that Mandala is an institution, and that the Kansas Residential Landlord Tenant Act is not intended to apply where residence is essential to any other primary purpose. And in this situation, Mandala provides a variety of services similar to geriatric, educational, or counseling institutions. Counsel referenced the Mandala employee who testified. She testified that Mandala is a state licensed provider of services for people with IDD, that they are subject to licensing regulations under Article 63, that their services are dictated by individuals' person-centered service plan. Services include at-home and out in the community supports. The personal plan is highly detailed and regulated and meant to move the individual toward achievement of their preferred lifestyle and is created with the assistance of the individual and their care team. Services are billed through Medicaid. Just viewed as a whole, the services provided by Mandala stem directly from the personal, functional, medical, and educational training needs of the person due to their intellectual development disability. Mandala's clients cannot fully thrive independently, and the services are similar to other institutions listed as exempted from the Kansas Residential Landlord Tenant Act. I would note that a client does not have to live at Mandala to receive services, but to live at Mandala, one must have an IDD diagnosis and receive services. So this demonstrates that living at Mandala is incidental to the primary purpose of Mandala, which is to provide or the provision of community and living services. Room and board is under a separate agreement for individuals who choose not to live as independently as others, or who may live in the community under the landlord-tenant agreement. But Mandala's lease is different from the standard, as it requires proof of a HCBS IDD Medicaid waiver and Social Security disability payments. During her testimony, Ms. Jackson agreed that Mandala does more than provide a private landlord would. The lease provides Mandala with the right of entry without notice, which is different than the typical Kansas Residential Landlord Tenant Act requirement of reasonable notice. So because living at Mandala is incidental to the services they provide, our assertion is that the Kansas Residential Landlord Tenant Act does not apply.
Do you have any comment on the suggestion that this appeal might be moot?
I do, Your Honor. And we did anticipate that this might come up due to the fact that our client is no longer living at Mandala, and therefore an eviction is no longer needed. To a certain extent, I say we somewhat agree with counsel in that Mandala is still listed as an agency-directed residential shared living provider in the Sedgwick County DDO directory. And would note that because the mootness doctrine is a court-made doctrine and is not jurisdictionally based, it is amenable to exceptions. One of those commonly applied exceptions is a circumstance where a moot issue is capable of repetition and raises concerns of public importance. In that type of situation, your review is unlimited. Just in summarize on that issue, Your Honor, the question of whether a residential facility like Mandala and its residents fall under the Kansas Residential Landlord Tenant Act, thereby giving the district court jurisdiction or stripping it of jurisdiction to hear eviction or other landlord tenant disputes is an issue which is capable of repetition and raises concerns of public importance. Such residential facilities will undoubtedly have situations in which they wish to terminate residency, and the residents will be placed in a position where they are being asked to leave for lack of payment or other violations. That is evidence that it is capable of repetition, and whether or not such residents, including our client, who is intellectually and developmentally disabled enough that they require ongoing supports in their daily lives in a residential environment, is clearly a matter of public importance.
Counsel, what's your response to the argument on the other side that if this arrangement doesn't fall under this act, that that residents like your client would lose some important protections that the act provides?
Excuse me, Your Honor. I think one of the issues, and correct me if I'm not on point here, is that there are other remedies available to Mandela and similar facilities that are supposed to handle the removal of residents for non-payment or violations of the agreement. When looking at the residential agreement attached to the original petition for eviction, they have several references that touch on that. In their paragraph 28 and 29, they seem to follow the Kansas Residential Landlord Tenant Act to some degree. But Mandela, if excluded from the Kansas Residential Landlord Tenant Act, cannot use it as a remedy by simply stating so that it's a residential contract. Paragraph 39 points to the other remedy available to Mandela, which is their dispute resolution policy. So,
And I apologize if I wasn't clear. I wasn't talking about the rights of the landlord. I was talking about the rights of the tenant. Like in your client's position, I understand, and one of the arguments on the other side is, look, if this arrangement isn't covered under the act, then your client is hurt because they don't get the benefit of the rights that are set forth in this act that protect the tenant.
and Your Honor, I think in this situation, the right here that's applicable is a right for the facility, not a right for our client. In that this allowing this situation to come under the Kansas Residential Landlord Tenant Act allows a company or an institution like Mandela to evict someone in our client's situation. And quite frankly, that does not take into effect the other services that are required and the other avenues they have available to remove someone like our client.
But just
So-
because the case came here under the landlord's attempt to evict, I mean, the ultimate question is whether this entire act applies to this arrangement, correct?
Yes, Your Honor.
And that would include your client's ability to enforce rights under the act against the landlord.
Okay, I see. Judge, I believe public policy of working with IDD adults and providing assistance to enhance their dignity, independence, integration into community, and allow for choice services, and the same rights as for people without disability, including tenant rights, is honorable. I believe being able to evict a person from their home is not a tenant right. Further, they are arguing, or the argument is that the public policy, they're arguing the public policy of HCBS, not the Kansas Residential Landlord Tenant Act. Their argument gets into the congressional intent to allow people to be free of institutionalization or have freedom of movement. But it's our position that there are alternatives outside of the Kansas Residential Landlord Tenant Act for clients like ours, who, based on the services that they're being provided by Mandela, find themselves in a situation that is not directly comparable to someone who's renting an apartment somewhere else.
You've got about 1 minute.
And Your Honor, I think at that point, we're finished with the argument.
Thank you. Mr. Albin, we'll return to you for your 2 minutes of rebuttal.
Thank you, Your Honor. 2 points I'd like to point out from the argument is the definition that they used all involved different types of facilities that you had no choice of residence. Whether or not it was a dormitory, you had the choice of living in that dormitory, but they were allowed to choose for you. You're allowed to choose which nursing home you go to, but you're not allowed to choose which room you're put into. You're not allowed to choose any of it. It's the freedom of choice here that separates a facility like Mandela out from those that were listed, specifically those like prisons or anything else. Other things that would be similar to this would be like an Oxford House living, where you have to be applicable to the actual program for living in that house. You can't just admit anybody into an Oxford House and tell them, oh, you have to follow the rules of the house, which include not drinking, which staying sober. The overall argument here is that not only does the Residential Landlord Tenant Act apply to both tenants and landlords in this situation, but by seeking only administrative regulations, you're stripping jurisdiction of the court to hear basic eviction cases that they're able to hear for facilities like this that are mandated by law to offer their services regardless of where they live. And so once again, we rest upon our argument that that Mandela doesn't apply because of the freedom of choice of where you live. You're not confined. You're able to move. You're able to travel. And that all those other things are listed to limited of those choice. And by the public policy that's listed between the ability to right to choose, that this should be remanded with specific instructions.
All right, counsel, thank you very much for your briefs and your arguments. You both did a very good job today. As I said earlier, we will take the case under advisement and you'll hear from us just as soon as we possibly can get to it. Thank you very much. And with that,